Hi, I'm Jane Dearwester with McIntyre Elder Law. Welcome to March Madness, McIntyre Elder Law style, where we're going to do a face-off here of a general durable power of attorney versus a will. And I'm going to talk about these two items, the pros and cons of each one, and then we're going to pick a winner.
Y'all ready for this?
Okay, we're going to talk about the general durable power of attorney versus a will. So when we're doing a face-off between these two documents, I'm going to start with the general durable power of attorney. This is potentially one of the most important estate planning documents, but people aren't always as familiar with this document. The power of attorney allows you to appoint an agent to handle your legal and financial affairs. So this has to be someone you really trust because they're going to have access to do anything you can do legally and financially. They'll have access to your bank accounts. They'll be able to buy, sell property, make gifts to themselves. And for most people, if you're a married couple, you'll appoint your spouse as your primary agent. And then usually most people appoint one of their children or a friend or family member as a secondary agent. What's very important about the general durable power of attorney is it endures if you become incompetent. So if there is a time when you lack capacity to make your own decisions, the power of attorney will allow your agent to be able to act on your behalf at any time. And it also has some protections in there to restrict them and to benefit you if they act against your wishes. I have some litigation cases right now that we're working on where power of attorney agents acted badly. But for the most case, you just want to pick someone that you trust, know that there are protections there to protect you, and it gives you protection while you're living and when you're most vulnerable. So we highly recommend a general durable power of attorney. On the flip side, we've got the last will and testament. This document is probably the document that most people, majority of people that come in, are familiar with. Most people have heard of a last will and testament. So a big difference between a general durable power of attorney and the last will and testament is the last will and testament only comes into effect after you die, after you're deceased. At that time, the person you pick, who might be the same as your agent under the power of attorney, is called the executor. So under your will, you appoint an executor, and it's that person's job to deal with all the particulars of your estate after you're gone and to work with the court, with the clerk of court's office through probate to make sure your assets are distributed according to your will. If you don't have a will in place, North Carolina has laws. It's called intestate succession. And if you don't have a will in place, your assets will be distributed the way the North Carolina legislature has dictated they will be distributed. And mostly that goes to your heirs at law, your blood kin. But if you want to distribute assets differently, without a will, you're not going to have a choice. So if we have a face-off between these two documents, when clients ask sometimes, hey, I can't afford necessarily to do everything all at once, which one should I pick? I'm always going to recommend the general durable power of attorney because that protects you now. It provides protection and convenience now while you're living and also when you're most vulnerable. The last will and testament doesn't become effective until you die. And again, even if you don't have a will, the state of North Carolina has statutes and laws on the books that will serve to help your assets pass to your loved ones, to your heirs at law. So in a face-off between these two, I'm going with the general durable power of attorney.